Morning, everyone, and welcome to our webinar. It's our second one for the year. This time, we're talking about conflicts of interest, and it's always a topic that's extremely conflictual, as luck would have it. For those of you who've come here thinking that this is about resolving conflicts with your manager, I saw that some people had asked questions about that. You're at the wrong webinar, but I encourage you to stay anyway, because I think we're going to deal with something that's very, very interesting. Conflicts of interest have exploded in South Africa, and I think part of the reason is because of COVID. The job insecurity that came about during COVID had caused a lot of people to look at alternatives to their existing employment, as well as the shift towards working from home or working remotely. It's given employees some sort of idea that they could perhaps participate in things outside of their work at the same time. So I think that this is a particularly difficult topic to talk about. There is lots of case law on this, and as employment lawyers, we deal with this almost on a daily basis. So what we've done is we've assembled the sharpest minds at CHM to deal with the issue. And I'll just introduce them briefly. First up, we'll have GAEL BARRABLE. She's a partner in the employment law practice. And then after that will be JEANNETTE VLOK. She has just joined the firm in our Cape Town office. She's also a partner in the employment law practice. And then COURTNEY WINGFIELD, a senior associate in the employment law practice, will finish us up. And they'll run through the various cases and principles that you need to know. At the end, we'll look at remedies, and then there'll be some time for Q&A as well. So if you have a question, please use the Q&A function, and then we'll take it from there. So let's not waste any more time. There's quite a lot to get through. Let me hand over to GAEL.
Thank you, Neil. Great. Okay, so my task is to essentially introduce you to the fundamental principles around conflict of interest. And I'm going to be referring to some fairly old cases. The first one is SAPI Nova Board and Villiers. It's a 1998 decision from the LAC. And the facts in this case relate to Neil. Sorry, if you could go to the next slide. All right, so Villiers was a non-practicing attorney, and he was employed in the financial credit department of SAPI. And a customer of SAPI at the time, which was called Kitchen City, was facing financial difficulty and could not make regular payments to the company. So Villiers decided, in his wisdom, that he would introduce this customer to a finance company, essentially called Mr. King, who agreed to finance their operations in exchange for shares in the business. Now, Villiers, in his wisdom, decided that he needed to be compensated for this introduction, and he requested a 10,000 Rand commission from Kitchen City. And after they prompted him for an invoice, he produced an invoice under the name of L. Villiers, as if he was a practicing attorney. So they paid him the 10,000 commission. Obviously, SAPI was not aware of this payment to him. And as it would happen, the truth does eventually come out. And Kitchen City was liquidated many years later. And the liquidators went into their investigations, and they discovered this commission that had been paid to Villiers. So he admitted to receiving this 10,000 Rand, and obviously the company was not happy about this. They had an inquiry and found him guilty, and he was dismissed. Now, the matter then went on to the industrial court in those days, and the issue before the court was whether his dismissal was fair or not. Now, interestingly, the industrial court found that his dismissal was unfair, and he was awarded compensation. The matter went to the Labour Appeal Court, and they disagreed with this finding that Villiers' dismissal was in fact fair and awarded costs against him, which is quite unusual. Now, in unpacking the legal principles in this case, the LAC essentially found that there is an implied term in an employment contract that an employee owes his or her employer a duty of good faith and to serve the employer honestly and faithfully and to act in the best interest of the employer. So this is really the foundational principle, that it's the duty of good faith and to not act against your employer, but to act in its best interests. Also, the court found that employers are actually in a fiduciary position to the employer, and they may not use that position for their own personal benefit without full disclosure and consent from the employer. So the term fiduciary, one automatically thinks of fiduciary duties that a director owes to a company. Now, the court has come out to say that employees have the exact same duty as well, and they're calling it a fiduciary duty. In other words, you may not put your own personal interests above that of your employer. So the court said in that case that the liability for breaching this fiduciary duty arose from the mere fact of a profit being made. So the commission that he earned was the profit, and it was actually applicable regardless of whether the employee was guilty of fraud, which is intentional misrepresentation, or dishonesty. So it operates from the mere fact of a profit having been made. And then finally, on this case, the court held that the secret commission that he had earned, these were considered to be in serious breach of his duty of good faith, as well as his fiduciary duty. Interestingly, in that case, the court did find that he was deliberately, he had engaged in dishonest conduct there. All right, so the second case that I'd like to refer to is a 2004 decision. It's the matter of Phillips and Fieldstone, Africa. It's a Supreme Court of Appeal case. Now, in that case, the employee concerned, who was Mr. Phillips, he was employed by a US company, which was represented in South Africa by Fieldstone Africa. And the South African company, he was, in terms of his arrangement with them, he was seconded to a third company called S Pty Limited to provide it with services to enable it to acquire shares in an SA cellular phone network. Now, a few months after taking up the secondment, Mr. Phillips purchased shares in S company for 732,000 rand. It's a fairly substantial sum. And obviously the company at the time was not aware of this purchase of shares. 8 months later, Phillips was appointed as a director of this S company, and the respondent, or his employer at the time, did not object. They were aware of this directorship, which often happens. As time went on, Phillips fell out with this S company, and he decided to sell his shares 3 years later for a sum. Sorry, I can't read the sum that was there, but it was a substantial amount. And he sold his shares for a very good profit. Now, the company became aware of this, and they decided to sue Mr. Phillips for damages in the amount of 11,250,000 rand, which was the difference between what Mr. Phillips had paid for the shares and what he got for selling those shares years later. So the profit that he had made out of that. So the matter went on to court, and it was alleged by the respondents that he had breached his duties of loyalty and good faith that he had owed when he acquired these shares in S company. Now, Phillips admitted that he owed a duty of loyalty to the respondents, but he denied that he acted as an agent for the second respondent, which was the Africa company, in relation to the contract with S company. He said that the offer of shares was not a corporate opportunity for the respondents, and he alleged that they were in fact aware that he had accepted the shares. Now, the court found, the court held that Mr. Phillips had placed his personal interest in conflict with his duties that were owed to his employer and ordered him to account to the respondents for the profits that he had made. The Supreme Court of Appeal upheld this decision. Just in terms of the principles that we can extract from this case, Court said that there is no magic in the term fiduciary duty. And what's important is that you have to examine the substance of the relationship between the parties. The court found that clearly Mr. Phillips had a fiduciary duty as an employee to his employer. And the court upheld the general principle of law, which is a principle that has been in place since 1921. This was the Robinson versus Randfontein Estates gold mining case, where the judge had said there that where one man stood to another in a position of confidence involving a duty to protect the interests of that other, he was not allowed to make a secret profit at the other's expense or place himself where his interests could conflict with his duty. So this is a very long-standing principle, as you can see. Now, the court said that the question was not whether Phillips had appropriated the opportunity belonging to the respondents, whether he had appropriated it for himself, but whether he had stood in a fiduciary relationship to them when the opportunity became available. Court said that Phillips had been in a position of trust to the respondents, and he was required to place their interests above his own whenever there was a possible conflict. So in that case, as I've said before, he was ordered to repay the 11.2 odd million that he had received as a profit. All right, now the last case I'm going to talk about is also a 2004 decision. Again, it's an SCA case, and it's the matter of Gaines and another versus Telecom Namibia. Now, the facts in that case were as follows. Thanks, Neil. All right, so Gaines was employed by Telecom as its manager of procurement for a period of about 5 years. Now, Telecom had an exclusive contract with D Company, who purchased all of its scrap copper. Gaines was responsible for implementing that contract and ultimately administering this contract. Telkom had brought an application to sequestrate Gaines and various other parties who some of them happened to be family members of Gaines, on the basis that they were indebted to Telecom for various amounts due. And these amounts were, for example, payments that had been made by Telecom to SARS, which were found not to be owing to SARS. Also for under-invoicing to D Company, overpayments of a housing subsidy, repayment of a car allowance, and an amount that was owing for copper that D Company had received, but Telkom had not received payment for that. Now, the court ultimately upheld the Court Aqua's decision that he should be sequestrated. Now, the principles that we can unpack from this case is that as an employee of Telecom, Gaines owed them a duty of good faith. This duty entailed that he was obliged not to work against Telecom, the interest, but to place himself in a position where his interest did not conflict with that of the company. And he was not to make a secret profit or receive from a third party a bribe or any secret commission in the course of his position as an employee. Gaines, the court ultimately found, had breached his duty of good faith to Telecom, and the payments he received for the bribes and the underhand payments, the court found that Telecom was entitled to recover those amounts from Gaines. So that completes the cases. I just want to mention that in my practice, I have come across a few examples of conflict of interest. And perhaps just worth mentioning is that one often finds that the requirement to make disclosures, so for example, disclosure documents which employees are required to sign, those disclosure policies are often linked to conflict of interest situations. And in this particular matter I handled, it was a situation where a fairly senior manager who was involved in procurement had failed to make disclosure of a company which was supplying to another supplier of the company, but that company was in fact owned by this person's wife. And that often happens where there are family members who are involved, and employees don't see the need to make disclosure of family connections, where they will simply argue, well, I'm not benefiting out of it, it's actually somebody else, it's my wife. And in that situation, it was very clear, fortunately for the employer here, the disclosure documents made it absolutely clear that any association, whether it be by the employee, his or her family member, or friends that were connected, all of that had to be disclosed upfront before any contract could be entered into, any supplier contract. But it's just something to bear in mind that those disclosure documents are really, really, or at least policies are really important. And an employer should attempt not to limit those disclosure documents in such a way that there can be a loophole for employees to argue, well, it doesn't cover my scenario. I think it's important that they must be wide enough to cover almost every possible situation. Thank you. That concludes my contribution.
All right, next up, we'll have Courtney to take us through some more cases.
Thanks, Neil. Thanks, Gail. My section really deals with an employee's interests, their own interests conflicting with the employer's interests. And the first case I'm dealing with is COETZER Development. In this case, there was an employee by the name of Mrs. Fort, who was employed as the unit head of safety, health, environmental, and quality. And during 2012, a vacancy for a document control officer arose. The company tried to fill the position internally and was unsuccessful. And so they looked outside of the company for someone who can be appointed into this position. Mrs. Fort's story was that she accompanied her friend or her boyfriend or her husband, and I'm not being facetious by saying that. She gave 3 different versions as to who this guy was. And during her lunch breaks, she would accompany him to his attorney's offices because he had a legal matter that he was dealing with, and that is where she met this Mrs. COETZER. And I've just checked, this Mrs. COETZER in this case is not related to Neil in any way. So she spoke to Mr. Songono, who was the recruitment consultant, about hiring Mrs. COETZER. And Mr. Songono was basically said, yes, if her CV is in time, then the recruitment panel will have to consider it. So on the 12th of July 2012, after the deadline for the applications had closed, Mrs. COETZER sent her CV to Mrs. Fort. And it was a very generic CV. It was, I have these qualifications, I have these skills. And the big problem was Mrs. Fort never sent it to Mr. Songono after he followed up 3 or 4 times. And obviously what was happening in the background was revealed on the 25th of July in 2012, where Mrs. Fort sends a different CV of Mrs. COETZER to Mr. Songono. And it was a very detailed CV. It was exactly what the position required. And there was a suggestion that it was actually drafted by someone who had sight of the job spec or who may have even been involved in the recruitment for this position. And during the investigation, the reason for this detailed CV was that Mrs. COETZER apparently had taken the advice of some unnamed HR manager, not at the company, who had advised her to amend her CV as follows. But anyway, we're getting ahead of ourselves. On the 30th of July, the selection panel sat, and Mrs. Fort was unsurprisingly the recruiting manager. She was the senior manager in that team. She disclosed, to her credit, to some extent, that she knew of Mrs. COETZER because she had obviously seen her at this attorney's firm. The panel went on to score Mrs. Winter first, a different candidate, external candidate, and Mrs. COETZER second. And this is not a surprise because Mrs. Fort scored Mrs. COETZER the best by far. And at the conclusion of the interviews, only that there was one position available, Mrs. Fort came up with a great idea, apparently which arose at the while she was sitting on the recruitment panel, that why don't we actually employ 2 document control officers? So she gets the necessary approvals from senior management, and ultimately Mrs. Winters and Mrs. COURTNEY were employed. And during an investigation, one of the employees came forward and said, from the outset, the relationship between Mrs. Fort and Mrs. COURTNEY was too close for comfort. The word to use was that it was more personal than initially stated. So that's the first incident. The second incident is there's Mrs. Fort meets Tala Ibrahim, who is the friend, boyfriend, or husband's brother, who apparently she was having coffee with her friend, boyfriend, or husband, and the brother strolled past by happenstance on the street, and she bumped into him, and he says to her, hey, if you have a job at your company, let me know and I'll apply for it. So anyway, she says, send me your CV, and she sends it on. So she speaks to Mr. Davids in this scenario, where he was the recruitment consultant in this scenario. And the company, he said, well, we must run a competitive recruitment process. And she says, okay. And after the company was unable to find any other candidates through this process, Mrs. Fort suggested that the company only interview Tola. But this was after David says, we need more CVs. And Mrs. Fort says, but there aren't any other people applying for this job. And then she sends an email to David's later saying, this guy's really stalking me. Can't we get back to him on this position? And Mr. David sort of fobs it off. And then Mr. David says, oh, well, when is this position actually going to become available for fulfillment? And Mrs. Fort replies immediately. She says, well, it's going to be immediately fulfillable. So anyway, she sits on the selection panel again, and surprise, surprise, Tala is appointed. 6 months later, after both Tala and Mrs. COURTNEY are appointed, there is a whistleblowing allegation that Mrs. Fort's friend or boyfriend or husband is related to this Mrs. COURTNEY. And 2 investigations follow, and 2 versions of the relations are given by Mrs. COURTNEY. She firstly says, well, she doesn't know Mrs. COURTNEY, she knows her from the attorney's office. And then secondly, she says, no, she knew Mrs. COURTNEY, she's related to her boyfriend, husband, and she met her at his apartment one day. Anyway, during this investigation, obviously the pressure's rising, and she says to the external investigator, why don't you just drop this investigation? There's no point. And thanks and credit to the investigator, he says no. Ultimately, Ms. Fort is charged with conflict of interest and dishonesty and dismissed. The CCMA, in its wisdom, found that because they couldn't prove a relationship between Mrs. Fort and Adnan, who is the husband-boyfriend, that there is no conflict of interest inherently, and there's no dishonesty. The Labour Court doesn't agree with that, and it's a really long judgment where the Labour Court goes on and on about it. It scrutinizes every single version given by Mrs. Fort, but basically it finds, as a result of the irreconcilable versions given during the investigations, both of them, and the disciplinary hearing and the arbitration, that she obviously knew Mr. COURTNEY before procuring the first CV. So her big trump card was a photo of her and Mr. Ibrahim at the rugby, looking all friendly. And the judge in the Labour Court didn't say that was very persuasive. The Labour Court found that Mrs. Fort and not some unnamed HR manager had assisted Mrs. COURTNEY in formulating the second CV. That was the only plausible inference to be drawn from those facts. So then the Labour Court's finding on conflicts of interest. They said that when Mrs. Fort sat on this recruitment panel, the selection panel, she was required to make a full and frank disclosure to her panelists, and not just with the full extent of the relationship between her and any related party, including Mrs. COURTNEY and Tala. And not the one that she had made. Oh, well, I know her, I've seen her at this attorney's office. If she had done so, the court found, on these facts, she would have had to recuse herself. And by not doing so, she acted in conflict with the company's interests. The court went on to say, the failure to disclose a conflict of interest is devious and deceptive, which is in essence dishonesty. And by scoring Mrs. Coetzer the highest, Mrs. Ford perpetuated the conflict of interest. On a selection panel, she was required, and this was the counsel for the applicants, or the appellant in this, or the applicants' counsel, say that she was required to be absolutely ice cold and could not be in a position to treat the candidate with any degree of favoritism without having made a full disclosure. So the court, in its actual words, said, put differently, it amounts to serious misconduct to become involved in a recruitment process of people to whom you feel favorable. That's important. And then in circumstances where you do not make a full disclosure. So it's not necessarily that because you could have a favorable feeling towards someone that it's ultimately a dismissible conflict of interest. It's not. That must be coupled with the failure to make a full disclosure. And on this basis, the court found the dismissal to be fair. The second case I'm talking about is Schwartz versus Sasol Polymers. It's a Labour Appeal Court case, and it's quite jarring as well. In this case, the employee in question worked for Sasol for over 20 years, and he accepted that the Sasol has a policy required to disclose any gift of over 500 Rand. And get ready for it. Yeah. He received 3 cycling sponsorships for his wife, 1,000 Rand to participate in the Argus cycle tour, 4,000 Rand cash for his wife, perfume and earrings for his wife, an ice cream maker, a frying pan, a DVD player, a box of whiskey, and a BMW jacket valued at over 5,000 Rand. But there's more. He also received work on the wife's bicycle for free, 2 BMW helmets for the price of 1, and various sums of money. The worst thing is that the wife, who's now the ex-wife, records a phone call with him where he says to her, when it comes to the gifts and the stuff, they can tap me over the fingers and that's it. And then when he said, in respect of the receipt of money from the service providers, that would get him fired. So he obviously knew what was coming. In its wisdom, the CCMA, however, finds that his dismissal is unfair because the rule in respects of gifts was not well known. And the CCMA found that a final written warning was more suitable in the circumstances. The Labour Court agreed that the dismissal was unfair, but substituted the retrospective reinstatement order of the CCMA with one of 12 months remuneration. The Labour Appeal Court didn't really agree with that. It said, the employment relationship obliges an employee to act honestly, in good faith, and protect the interests of the employer so as to avoid conflicts of interest that may arise, which may breach his duty. So it's a positive act. You must protect the employer's interests. The appellant was employed in a senior position, which is important, as an engineering manager. And this is essentially what conflicts of interest come down to. His calculated silence in the face of a duty to speak amounted to fraudulent non-disclosure or concealment of the true state of affairs in circumstances in which gifts and benefits earned secretly fell to be disgorged by him with little room to avoid the consequence. His conduct was, by its nature, dishonest in circumstances in which he was obliged to act with honesty, diligence, and good faith towards his employer, and not allow his own interests to prevail over those of Sasol. The court went on, in the current matter, the dishonest nature of the appellant's misconduct was of such a nature as to make continued employment intolerable and dismissal a sensible operational response to risk management. It would be fundamentally unfair and unjust to expect an employer to retain in its workplace a senior employee who has shown himself guilty of dishonesty in the manner of the appellant. The high premium on honesty in the workplace and the presence of dishonesty makes the restoration of trust, which is at the core of the employment relationship, unlikely. On this basis, obviously the Labour Appeal Court is not mincing its words, and it found his dismissal to be fair. All right, this is the final case I'm going to deal with, and I can say I I find the ultimate finding of the Labour Appeal Court in this case quite confusing, but we'll go through it anyway. In this case, the employee was employed as a procurement clerk for over 15 years. And, you know, as GAEL said earlier, procurement clerks are generally involved in this kind of conflicts of interest because they always act in a position where they could sort of influence the process if they really chose to do so. And I mean, as anyone will tell you, a lot of the conflicts of interest happen in the procurement department. So in this case, the company had a strict rule on disclosing conflicts of interest. The complaint was made later where the company allegedly did not pay grace security for services rendered. What happened in this case was the company had contracted Genesis to fix its alarm, and Genesis subcontracted that to Grace. So 2 technicians employed by Grace called a meeting with Genesis so that Genesis could grant them a loan to perform the work. Anyway, more bizarrely, Genesis agreed to loan the money, which would be paid into the employee's bank account. So this procurement clerk who works for not a related company, it's not Genesis or Grace, she works for De Beers. So the money is paid to her. The 2 technicians were tenants of the employee. They resided on her property and they paid her for that and did not have a banking account. So she said, well, let me allow them to use mine. The employee was paid 20,000 Rand. She withdrew 15,000 Rand, which was paid over to the technicians. 2,000 was paid over 2 days later. And then 3,000 Rand was completely unspoken for. Later, the employee says that she handed her bank card to the technicians so that they could spend that extra 3,000 Rand. And the court will deal with that a little bit later. All right, so Grace completes the task and they send an invoice to Genesis for 8,000, which was marked up by Genesis to 11,500 and was sent to the company. So Genesis was paid by the company. So De Beers is out of this thing. And they refused to pay Grace. So Genesis was paid. They refused to pay Grace because Grace was still indebted to it because they had given the loan. The dispute arose obviously in the whistleblowing complaint by Grace, but the employee, as soon as that happened, the employee decided, ooh, this may become trouble. So let me go and disclose that the 2 technicians live on my property. And that's all she says. Later in a disciplinary inquiry, she says, well, she didn't actually benefit from this transaction as it had nothing to do with the company, the payment into her account. So why would she have to disclose it? Naturally, the employee was dismissed and the CCMA again finds the dismissal unfair. The employee did not know where the money came from, which is their finding, and there was no risk to the company. The Labour Court dismisses the review application. The Labour Appeal Court says her involvement by being present at the negotiation of the loan and its payment into the bank account obliged her to make the disclosure. So just being present at the negotiation and the payment of the loan into her account required her to disclose that. The employee was not, the ironic thing of this was that the employee was actually part of the meeting where the loan was discussed and agreed to. So how could the CCMA have found that she didn't know where the money came from? The Labour Appeal Court went on. The dispute was just between Genesis and Grace, and it would have easily been explained by the company, but for the involvement of the employee. So if Genesis hadn't paid Grace, Grace and Genesis could have had a dispute amongst themselves. The problem is that the employee was now involved. It was paid into her bank account. They lived on her premises and all this other stuff. So now the company, De Beers, is now involved in this whole scenario. So the Labour Appeal Court says, even if the employee simply facilitated the service that was rendered to the appellant by providing her bank details for Genesis to make payment to Grace, then, in my view, she had a duty to disclose that information, even if she didn't benefit. And it goes on to the appellant, and a failure to do so must constitute a breach of the rule, and as such, she was guilty of the misconduct. So the court went on to say whether she received any benefit was totally irrelevant. and a version that she permitted the technicians to use her card is so far-fetched that it had to be rejected. This quote quoted on the slide is not correct, but the court went on to say in paragraph 19, as an employee in procurement, so like I say, procurement is always important, specifically dealing with outside service providers, the employee could not ignore that Genesis, and therefore Mr. Mabasa, who was the service provider, was a service provider of the appellant. This should have alerted her to the need to disclose the deposit. The simple fact that the employee had received money from Genesis, a service provider, is on its own a conflict of interest, and she should have disclosed that. So the final point here, the court says, however, on a holistic assessment of the evidence, it shows that she was involved with parties who were service providers to employer, and as such, she had a duty to disclose this. So the court found her dismissal unfair, and this is where I don't necessarily just agree with the Labour Appeal Court. They said that because she was employed for 15 years, a final written warning could have sufficed in this scenario, and they limited the retrospectivity of her reinstatement. And Neil will deal with the remedies for employees who act in conflict of interest a little bit later, but those are my cases. Thanks, Neil.
Thanks, Courtney. Next up is Jeanette, and she'll be dealing with the last set of cases before we get to the remedies and then Q&A after that.
Thanks, Neil. Good morning, everyone. So the cases that I'm going to be dealing with are a bit more recent. The first case is the Bakenrug case, which relates to running an overlapping business. In this case, the employee was employed as a sales representative for an employer who produced and sold meat products. The employee then had her own business in which she marketed biltong, which, as we all know, is a dried meat product. She ended up being dismissed for dishonesty because she failed to disclose her business of marketing the dried meat products to her employer, and of course to give her full attention to the business of the employer. That case went on to the CCMA. The CCMA found the dismissal to be substantively fair, effectively on the basis that her failure to inform the employer that she marketed meat products was dishonest, as the employer should have been made aware of that conflict so that the employer could decide whether the activities were in fact in conflict. The obvious issue that she couldn't have given her full attention to her duties. The CCMA found that it was irrelevant that the meat products weren't identical. So it doesn't necessarily have to be an actual conflicting product or product that could amount to competition. And this is the important quote that the CCMA then included in the award, which is, employees act in bad faith if a conflict of interest may arise, even though no real competition actually exists. So that was the important finding that came out of the CCMA, is that the conflict only has to be a potential conflict and there doesn't necessarily have to be competition. The CCMA award went on to the Labour Court, where it was reviewed and set aside. The dismissal was found to be substantively unfair. The Labour Court, contrary to what the CCMA found, said that there is no duty on the part of an employee to inform his or her employer about a potential conflict of interest. So where the CCMA said that there may just be a conflict, the Labour Court said you don't have a duty if there's a potential conflict of interest. An employee is only required to inform an employer about a potential conflict where there's some sort of competition. The Labour Court also found that the employee operated her business on weekends, meaning that there was no nexus between her performance for the employer and her sideline business. So her employment with the other employer didn't really impact on her employer's time during the day. The Labour Court also found effectively that the charge hadn't been proved, so took a more technical approach towards what the charge was actually framed as. The Labour Court's decision then went on appeal to the LAC, which overturned the decision. So this case is important to show how you could have differing views as a case runs through the CCMA to the Labour Court to the LAC. The LAC found that there was clear evidence that the employee did not disclose an essential and important fact that she was running a sideline business by marketing meat products. It was irrelevant that the meat products were not identical and that it didn't affect her performance. So they're agreeing with the CCMA's reasoning. She failed to disclose obvious material activities to her employer. The marketing of meat products was in violation of the duty of good faith to her employer. And then the Labour Appeal Court endorsed what the CCMA had found, where it said the conclusion reached by the second respondent that employees act in bad faith if conflicts of interest may arise, even though no real competition actually results, is unassailable. So the interesting thing about this case is you've got, as I said, two differing versions or viewpoints as the case moved from the CCMA through to the LAC. And the LAC came up or came back to the overarching principle of the duty of good faith, which, as GAEL explained earlier, already arose in the SAPI Novibord case. And you don't actually need a real conflict of interest. It can be a potential conflict of interest, and you don't have to be in competition with your employer. So you don't necessarily have to be able to show that you took business away from your employer. The next case that I'll be dealing with deals with circumstances where an employee ran a separate business, which is the Masekoa case. In this case, there was a senior official who provided accommodation at her guest house during an annual cultural event, which was initiated and financed by her employer, but through a mechanism, a contractual mechanism, which was with the Free State Arts and Culture Council and PSS. She declared her interest in her guest house in her annual declaration, but claimed that she thought that she was dealing with a private entity, so this PSS, and didn't know that it was linked to her employer. So the employee came up with this technical argument that, yes, this whole contractual mechanism was set up, but I was under the impression I was dealing with an external party, and in any event, you know about my guest house because I declare it on an annual basis. The CCMA found a dismissal procedurally and substantively unfair and ordered reinstatement with back pay. The Labour Court agreed with that and found that ultimately it was not unreasonable for the arbitrator to find that there was no conflict between the employee's official position and her guest house concluding business with PSS. So the Labour Court also looked at that contractual arrangement and found that it was between this external entity, PSS, and the employee. The finding was based on the employee not having had an influence over or involvement in the decision-making process. And we've seen in some other cases how that's usually an important consideration. For instance, the case where Courtney explained the selection panels, there's the issue of the influence and the involvement usually comes into it, and also in procurement processes. The other issue was she thought that she was contracting with PSS as a private entity. And the accommodation in Bloemfontein was unique. So she would in all probability have been approached in the normal course. So the fact that she worked there was not necessarily the reason why she got the contract. That case went on to the Labour Appeal Court. And the Labour Appeal Court looked at this contractual arrangement, but said we actually need to look at the crisp issue here, which was whether there was a conflict. And again, we get this concept of a potential conflict between the interest as an employee of the department. In this case, she was the chief director who was responsible for the management of the funds of that specific event, and her personal interest as the owner of the guest house. So the first issue that the Labour Court said you must look at is, what are the competing interests? Is there potential for conflict here? Not just is there an actual conflict here? Once you've established that, you look at the second issue, which is there actually a rule? Is that conflict in breach with her ethical duties in the SMS handbook, which was basically the policy that is in place in this department? The Labour Appeal Court then found, given the senior position that she had, and as I mentioned before, she was actually in charge of the funding for that annual event through that contractual mechanism that I mentioned earlier. The court found that it was unlikely that she didn't have intimate knowledge of how the event was arranged, funded and paid for, and what the source of the payment was. It was in fact her job to know what that funding was for and where the funding was going to go to. There was a potential conflict, if not an actual conflict, between the interest of the department through that contractual mechanism to keep the accommodation costs as low as possible, because obviously you wanted to be able to use that funding for other expenses as well. And that was in conflict with the interest of the employee, who wanted to make a bigger profit as possible for her guest house. The LIC found that even though there was no specific rule that said that she was not allowed to do business with the department, the SMS handbook, which was the department's policy on conflicts of interest, required her to disclose both an actual and a potential conflict of interest, and to take steps to avoid it. So the important part here is it's not only about actual conflicts, it's again also about potential conflicts. And in this case, it was very useful that this SMS handbook provided that you need to avoid those potential conflicts. It actually places an obligation on you to take steps to get yourself out of that situation. The court found that she didn't disclose all the details relating to the conflict or take any steps to avoid it, and dismissal was justified based on the position of trust that she was put in as a senior employee of that business. So just to get back to that case, even though that is a government case, so it's a government department, the same would apply to an employer, because you would also want to keep your costs as low as possible. And you don't want a situation where someone who is indirectly in charge of the funding could directly benefit by having her own business contracting with that employer. Then the next case deals with where remarks were made by an employee who didn't necessarily have the same viewpoint as its employer. This is the case of Becker. It went to the Western Cape High Court. It was a review application, which then also went on to the SCA on appeal. In this case, the minister appointed a non-executive director of the National Nuclear Regulator. That person was nominated for the position by civil society organizations, including the Coburg Alert Alliance. And the Coburg Alert Alliance, which then proposed him to become a board member, didn't agree with the safety of nuclear power, and therefore opposed building additional nuclear reactors at Coburg. They were concerned that the plant, the maintenance on the plant was not safe, and that pretty much additional capacity shouldn't be added. Then soon after this director's appointment to the board, the director wrote an article in an online magazine, not in his capacity as a board member, but in his capacity as a spokesperson of this KAA organization. And in that article, he effectively questioned whether the Coburg was safe and whether there was enough maintenance being done to increase the lifespan of the plant. The director also attended a board meeting where various issues such as the safety was discussed, and then immediately after that would convene a meeting to discuss the same issue with civil organizations. He also requested information in his capacity as a board member, but that information indirectly related to the issues that he had complained about in that article that he had published for the KAA. The potential conflict of interest then came to the employers, the employer's attention, and what they did was both parties obtained legal advice on whether this was actually a conflict of interest and whether the director should be discharged or removed as a board member. This was forwarded to the minister as the decision maker to decide what to do. And the minister gave the director an opportunity to make representations, as is normally the case, but effectively found that he should be removed as a director because he expressed critical views about the desirability of nuclear energy, which placed him in a conflict of interest as a board member. The minister then went and made a public statement, which became quite important in the case. The minister was quoted saying, "If you resist nuclear and you are a board member, I fire you. Simple. You can't be on a board of something you are not advocating for." So a very simple approach was taken to the matter, where the minister said, either you're with us and you share our views, or you're against us and you can't be a board member because it's in conflict with what we stand for. That is the decision that was taken on review to the High Court. And then in the High Court, it was found that the court actually looked at where did the minister get his powers from, and in what capacity was that director appointed to the board. So the minister derived his power from the National Nuclear Regulations Act, in terms of which we had appointed a person representing communities which may be affected by nuclear activities. So people were placed onto the board to effectively represent labor, business, and other groupings. The whole idea was to ensure that there was proper debate and deliberations within the board, and that it wasn't only one view that was put on the board. So just the view of pro-nuclear power and not necessarily environmental concerns, socioeconomic concerns, financial concerns. The director was therefore on the board in a representative capacity, and he was supposed to convey the views of those civic or civil organizations, including the KAA. The High Court found that when the director therefore wrote that article and convened the meeting, he wasn't formally appointed yet, and therefore there wasn't a conflict in how he had expressed himself in the article as a KAA representative. His request for information was linked to his actual capacity as a board member. So it was information that he should have been aware of in order for him to fulfill the functions as a board member. He had made various requests to the chair to clarify what his role was on the board. And the chair had not dealt with those requests and made sure that he knew where the line was, how this conflict had to be managed. An important thing that also came up was it wasn't dealt with swiftly. So the board wanted to say on the one side that this is such an important issue, you cannot remain on the board because there's this risk, there's a conflict of interest, but yet the board takes such a long period was taken to remove him. So it's important that issues of conflict of interest are dealt with immediately. And there's that, especially if you want to claim that it's such an important issue to the business. The decision to remove the director was declared unconstitutional, unlawful, and invalid and set aside, and with costs. That issue went on to the Supreme Court of Appeal. There, the arguments related more to whether or not he actually committed misconduct as a director. And that case at the Supreme Court of Appeal was dismissed with the cost to counsel. The important part is that the Supreme Court of Appeal confirmed that holding an opposing view is not necessarily a conflict of interest. And you know, you have many employees, just to link this case to other circumstances that often arise in practice, is you've got many employees that have social media accounts and that have, their own blogs. They are active on LinkedIn. They make various comments. The fact that an employee makes a comment which does not necessarily accord with what the employer stands for or would like to stand for is not automatically a conflict of interest. It all comes down to what the rules of engagement are. So what is in your policies? What do the employees know they are entitled to say and not entitled to say? And you need to look at that employee's actual job spec. What is that employee? You can't have someone, for instance, who's supposed to be a political activist, not have any statements on politics. You need to set clear boundaries so that that person knows exactly what it is that they are allowed and not allowed to say. Then the last case that I will be dealing with is where an employee actually contracted to work 82.5 hours per week, which roughly equates to 16 hours a day without any breaks. So the Vilakazi matter, it's a 2024 matter. So Ms. Vilakazi was employed at WITS as a part-time lecturer at its business school. And then at the same time, she also worked for Alexander Forbes, but WITS was aware of that dual employment, and it was with the consent of the university on the basis that it was part-time. So they didn't need all of the hours in her day. 10 months later, she then resigns from Alexander Forbes to take up full-time employment with WITS. The contract stated that she then had to work 45 hours a week. So obviously she appreciated that she couldn't work for Alexander Forbes and work for WITS at the same time on a full-time basis. A condition of her employment contract was that she had to familiarize herself with all of the rules and policies in the employer's workplace. And one of those policies was a declaration of interest, which dealt with conflicts of interest and moonlighting as a separate issue. The moonlighting was specifically important because it required the consent of the VC before the work was undertaken. And moonlighting was defined in the policy as taking up additional employment, which may require time investment that may impede a staff member in meeting his or her contractual obligation to the university. So the university understood that when you work for two employers, time and attention and energy is going to be taken away from WITS as the initial employer. And they wanted to make sure that that was regulated so that you don't run into a situation where the employee pretty much works till 2 o'clock in the next morning, or 2 o'clock in the morning, and then wants to show up for work at 8 o'clock the next day. The employee, pretty much just after she took up employment with WITS on a full-time basis, also signed an employment contract with Kantar as an accounts director, which she didn't disclose to WITS. Kantar paid her 36,000 Rand more per annum, which was more than she earned at WITS, and required her to work 37.5 hours per week. So it was another full-time employment position. She'd become a member, in terms of her contracts of both employers, she had to become a member of both medical aids and pension funds, which is obviously not practically possible. So that should have made it clear to her that this is not a workable arrangement. She was charged and dismissed for gross misconduct, and then you took up full-time employment at Kantar while still in the full-time employment of the university without the knowledge or authority of the university. Your conduct was to the prejudice or potential prejudice of the university. That dismissal went on to the CCMA. The CCMA found the dismissal to be fair, and the CCMA just took a logical approach by saying, working 2 full-time jobs, it's just not possible or sustainable. You may be able to put it up for a week or a month, but you can't do that on a continuous basis, so you should have known that this is not something that your employer would ever have agreed to. The CCMA award was taken on review to the Labour Court, where the Labour Court found that the two contractual relationships were mutually incompatible and couldn't practically exist together. You can't work more than 80 hours a week on a consistent basis. And then this is an interesting practical consideration that the Labour Court also came up with, which is, given that she was paid more by Kantar, there was little doubt which employer would get preference if both required work to be done at the same time. There was a real risk of a conflict of interest to the prejudice or potential prejudice of Wits. So even if she was able to do the full 82.5-hour work week, if there was two requests at the same time, she was always going to favor Kantar because the terms and conditions of that contract was more favorable. It was less hours for a lot more money. The Labour Court also found that the employer is the one who must decide if there's a conflict of interest that places its own interest at risk. It's not for the employee to make a subjective assessment. The declaration of interest and seeking of approval enables the employer to do so. So it's not for an employee to decide whether they think it's a conflict and whether they can conduct themselves appropriately. The important issue is the employer needs to be put into a position where they decide whether it's acceptable or not. In paragraph 59, the Labour Court summarized it, where it said, in simple terms, moonlighting as a matter of principle is unacceptable and a breach of an employee's fiduciary duties towards the employer. It must always be the sole prerogative of an employer to decide whether to allow this to take place and also on what terms it may be allowed. Nothing can be assumed by the employee. That is why it has to be critical that full disclosure be made by the employee to the employer beforehand, so that the employer can exercise its prerogative in an informed manner. To make a disclosure to an employer after the fact effectively confronts the employer with a fait accompli and cannot undo the breach of the duty of good faith that has already taken place. So here again, we see that the court draws in that duty of good faith, and it effectively finds that it is firstly a disclosure beforehand, and it is for the employer to decide. The Labour Court went on to say the persistent denial of the applicant in the face of all else, and that she had not done anything wrong, has another consequence. It leaves the third respondent with no other choice but to manage its risk by ending the employment relationship with the applicant. If the applicant cannot comprehend what her fiduciary duties toward the third respondent entails and fails to show even some modicum of appreciation that for her to take up permanent employment with another employer is wrong and may cause the proper discharge of her duties in the interest of the third respondent harm, the risk management necessitates the termination of employment of the applicant. Now, that's quite a mouthful, but basically what it means is the Labour Court took a firm approach to say, if you can't even understand that this is an unacceptable situation, so working 82 hours a week and contending that you're going to be working flat out for both employers without any of them suffering any prejudice, that's just completely unacceptable. And it poses a risk to the employer, meaning that you need to terminate. There's no other option. The review application was dismissed with costs on that basis. And I just want to make some general comments about conflicts of interest in general. So I think what is important from these most recent cases is that we can see that there were really differing views on how the cases went through the CCMA, the Labour Court, the LAC. So conflicts of interest is not clear-cut. It is something that needs to be managed very carefully with legal advice and immediately, swiftly, decisively. It's not only about declaring a conflict of interest once a year. These are things that need to happen on an ongoing basis, and it also needs to be monitored by employers. And then I just want to refer to one practical example which I've encountered in practice, which is where an employer it was wood that had become damaged and it was laying on site. And basically what happened is the employee came across this wood in the day-to-day operational functions of his job. And he decided, the wood is going to be thrown away anyway, so I'm just gonna take it. I'll pay a nominal amount for it, and I'm going to use it in my house. It was yellow wood, so there was a reason why he wanted it. And effectively, the argument there was that it was not for him to decide whether or not he was going to take this throwaway product. His argument was that it was rubbish. It was for the employer to decide what it wanted to do with it. So he had to disclose the potential benefit to his employer, and he had to say, the employer could have said, look, let's use this, let's donate it because it's good media publicity, or let's actually use it in our offices and make something with it, or let's put it up for more senior employees to decide whether they actually want it before this other employee just decides that he's going to take it. So the point is that these conflicts arise in very different very different formats, and it's often that employees say that, I didn't know it was a conflict, and that is why these very clear processes must be put in place. Thank you very much for your time, guys.
Thanks, Jeanette. So, just want to see if my camera's on. Yes, it is. Okay. So, look, we've been through a whole bunch of stuff so far. I think a lot of the cases deal with some of the more extreme examples. This last case that Jeanette dealt with was the one about the lady having 2 full-time jobs. I mean, this lady has immense amounts of energy. Many of us struggle with a single job, but she thought that she could do 2 and saw nothing wrong with it. But the real issue occurs when there are kind of borderline cases, and that happens almost on a day-to-day basis. And I promise you that if you go and do a search on many of your employees, you'll find that they have outside interests, they hold directorships. Whether those companies are active, whether they're still active, whether they're still listed erroneously as a director, whether they participate in NGOs, whether that's relevant to your business, all of those things you will have to deal with on a daily basis. So I thought we should look now, having considered what the law says, is how to deal with this from a practical perspective. And I think that, as with everything in life, prevention is better than the cure. And how do we prevent this? I think that policies are a good place to start, but policies can be both a good and a bad thing at the same time. And I think we need to understand why. We've heard a lot in this case about the duty of good faith, or in this webinar rather, about the duty of good faith and what that entails. We've heard about fiduciary duties and acting in the best interests of your employer. That is a very broad concept, and it's very useful. Now, once employers start putting policies in to deal with conflicts of interest, you essentially narrow that duty of good faith to an extent, because the issue of conflicts of interest is now dealt with in that policy. So it's very important to make sure that when we craft our policies on conflict of interest, we need to ensure that they're properly drafted. We need to ensure that they deal with the appropriate conflicts of interest. In one matter that I'm dealing with at the moment, there's a policy which speaks to only that a conflict of interest only arises if the person is involved with a competitor. And that may become a problem. What about supplier? That is a major issue, which is obviously an omission from the policy and could cause considerable difficulty. So what we need to do as employers is to sit and think about our businesses and what are the things that we need to guard against. What do we need our employees to disclose to us? What would impact materially on our business? If it is somebody who is a director of an NGO that feeds the homeless once a month or over the weekend, does that affect your business? It's an outside interest, and not all outside interests are necessarily conflicts of interest. If, however, that activity conflicted with that person's employment, then it may very well be something that needs to be disclosed. But all of those issues should be covered in a proper and comprehensive policy dealing with conflicts of interest. And it's not only setting out what is to be disclosed, it's also how it should be disclosed. So there should be a form that is filled out that is quite clear and understandable, so there's no room for misunderstandings. And of course, everything that employers, or the one thing that employers love to do is to do training for all their staff. This is one of those issues that we cannot omit from the training schedule. There must be regular training on the policies that an employer has to all of the employees. And as you go higher up the chain of authority in the organization, you know, the obligation to disclose is most likely higher. And of course, there are, and we've already touched on it in some of the cases, I think Courtney mentioned it in particular, there are high-risk areas in a business. And those are particularly, and we've come across this often in practice, procurement or supply chain management, and then legal and HR. You see, procurement deals with tenders and bids. They have access to information. So we had a matter not so long ago where a person who was employed in the procurement department was involved. It was a cement manufacturing company, but the employee had started a cleaning company on the side. Now that had nothing to do with the manufacture of cement, but of course this company that manufactures cement requires cleaners at its various operations. So this person sitting in supply chain was able to evaluate and gain knowledge on what the market prices were for cleaning contracts and what sort of prices she should be charging in her cleaning company. So, you know, all of these things need to be considered. And the same issue occurs with legal and HR, often with contracts of employment, service contracts, those sort of things, the appointment of suppliers, all of those things need to be considered. Now, if prevention doesn't work, then you need to turn to possibly some legal remedies. I did mention that not every outside interest is a conflict, but it must be determined on a case-by-case basis, as with everything in labor law. So it's very difficult to set hard and fast rules, but as I've said, the best place to start is with your policy. The next question that you need to ask as the employer is, can progressive discipline be applied? Is it necessary to dismiss in every instance? And that's something that employers need to think about. Often if there's a breach of the duty of good faith or some attempt to conceal, if there's some element of dishonesty in the failure to disclose, then that would probably warrant dismissal. And we say that dismissal is usually the outcome where there's a material non-disclosure of an outside interest. But dismissal may only be the start. There are, of course, other remedies available to employers, and we've dealt with some of them, particularly the early cases. This approach seems to have fallen away in the last few years, but it appears to have resurrected itself most recently, and that's claims for damages against employees. We saw recently there was the claim against the former head at I believe it was PRASA, Mr. Daniel Ntunkulu, who had forged his qualifications, and he'd made profits on that basis, and in profits he earned remuneration, in other words, that he was not entitled to. It's a slightly different context, but the principle remains the same, that where an employer has suffered damages, they should seek claims for damages to recover those profits or monies that they have lost. Where an employee has made a secret profit, as with some of the earlier cases that GAEL mentioned, they should be bringing applications for the employees to disgorge those profits, because those are profits that the employer should have been entitled to, but for the dishonest conduct on the part of the employee. One way to recover some of those amounts is through the attachment of the value of an employee's pension fund or provident fund. And you're entitled to do this in terms of the Pension Funds Act. Often we find that it's employees who've been employed for a very long time and become very comfortable in their employment, and they feel like they can take some chances here and there. And of course, if you've been at an employer for 20 years, there's quite a substantial value often in your pension fund and provident fund. And if you've made a secret profit, those funds could be used to satisfy the debt. So, and then of course, where an employer or where an employee is secretly competing with you, once you've dismissed them, there may be restraints of trade that are in place. And where you're aware that an employee has taken some of your confidential information, you could even bring an Anton Pillar order where you show up at their doorstep demanding that they hand over all of the confidential information in their possession. So I think that's about the long and the short of it. I think we'll get to questions now. I'm pretty sure that there are a few, but I think perhaps we could maybe kick off with a question. I'll ask this to the other panelists, and that is, and perhaps you guys could just turn your cameras on. I think perhaps we could start with this question. What do we say about a situation where somebody participates as the coach of a football team after hours, and they play their soccer quite late into the evening, and the next morning the employee is extremely tired when he gets to his real job because he's been coaching his team really well the night before, and this happens 2 or 3 times a week? Is that a conflict of interest?
Maybe I can start. I mean, ultimately, and it's also related to one of the questions here, we mustn't lose sight of the fact that everyone still has a personal life, and no one dedicates 24 hours a day to an employer. So, I mean, if it starts affecting your job, you must look into it, I think, definitely. But I mean, what is different between that and the guy who goes home and lies on the couch and watches Netflix until 11:30 at night and is also tired? So I think it's something that you need to regulate. But I mean, employers often they lose sight that you don't dedicate your whole life to your employer. Generally, your working hours and something after that if working requirements demand. But to me, I'd start monitoring them a bit closely. But I don't know if it's dismissible. Anyone else have a view?
Yeah, I think, Courtney, just I agree with you. We don't spend every waking hour dedicated to our jobs. But I think the question here really will be, to what extent does the employee's involvement in his coaching activities impact his employment? I mean, yes, you sit at home and watch Netflix, but is that happening every single night? In the case of the coach, yes, it's happening 3 times a week. And I think the point really is, to what extent is it actually affecting his ability to do his job? And I think you'll only know that over a period of time, but it's something worth monitoring.
Courtney does raise an interesting point, though, that if we get to a point where we're now concerned about our employees binge watching series on Netflix late in the evening and that affecting your employment, I mean, we've really reached quite a severe stage. And if your policy requires you to disclose something like that, I imagine that would be a problem.
Yeah, I think that it comes down to what the policy actually says, and I think that may be more of a performance issue.
Yeah. All right, so let's go to the Q&A. There's a question here from Anonymous. Can you assist with a scenario where you cannot prove that there were profits exchanged, but that a contract is awarded to your friend? You did not disclose the relationship. Anyone want to go for that one?
I think I'll start off. I think ultimately, if there's a I don't know about the last sentence there. You did not disclose the relationship, but ultimately, like Jeanette would have said, you're not obliged to prove that the employee received any benefit or any profit. So if there's a contract and it looks like this employee is running a business on the side and they've just landed a major contract, yes, I think so. Obviously, like everyone says, it depends on the policy, but I mean, ultimately, that's a good indicator that there's a potential or actual conflict of interest. And I think in that case, probably an actual conflict of interest. So we don't need to get too hung up, and maybe employers do get too hung up on trying to prove, or how much money have they earned into their bank account or something like that. And we don't really need to get too fussed on that. If you can prove it, cool. But I don't think you need to get too fussed on it.
All right, thanks. There's a question here from Michelle Joya. Hi, Michelle. She says, morning panelists, in light of the Barkenrug matter, apart from dismissing the employee, is there another form of recourse that the employer has, i.e. civil litigation against the employee? If so, how would you quantify the damage, especially if the employee only worked on weekends and it did not interfere with her time with the employer? Further, if the employer could obtain evidence that it did interfere with their time, how would they quantify the loss, and could they institute action against her? There's a whole bunch of them there. I think maybe, Jeanette, you spoke on Barkenrug. It might be useful.
Yeah, so look, I think it's not a situation of claiming back what the employee would have earned over the weekend necessarily. I think the bigger issue is, firstly, are you going to terminate that person's employment? And then, as the court said there, it doesn't necessarily have to be an actual competing business. If it is a competing business, though, yeah, I guess you could look at what Neil said about Anton Pillar. You could see, how did she run that business? How did she take client lists? Did she take, supplier information? Civil litigation, yeah, it's all going to come down to the facts. It's going to come down to, is it business that was taken away from the employer, and did you use the employer's actual information to benefit?
Okay, thanks. There's a question here from Leon Jacobs. Is it advisable to create a side hustle policy in order to make the stance clear? You see, the fact that we've created these terms and we're considering creating policies for them shows to what extent it's become almost socially acceptable to have outside interests post-COVID. We didn't speak like this before COVID. For instance, in terms of use of time, use of company resources, traditional moonlighting clauses were very strict. And in today's time, the side hustle culture is very prominent. It seems it might be more applicable to move from moonlighting clauses towards guidelines and rules regarding the side hustles. GAEL?
Yeah, I think I agree with that. I think the term moonlighting is not something we come across so much anymore. And I think this side hustle phrase is probably more prominent. And I think it's important that we try and provide guidelines on what's acceptable conduct and what's not. You know, the example of somebody selling, let's say, cosmetic products on a weekend, which is completely disconnected from the person's employment. I mean, I think it would be useful to define to what extent is that acceptable or not. You know, so I think, yes, I think it's a good suggestion that it must be something we need to formulate in possible policy guidelines.
Yeah, this is I think we've got two more questions, and then we're going to wrap it up. I've got one more. I've got a couple of properties. This is from Anonymous. I've got I've got a couple of properties that I'm renting out. Will that amount to an actual or potential conflict of interest because it's passive income? Who wants to take that one?
I can sort of give some thoughts on it, Jeanette. You can jump in. I think I don't think necessarily just receiving amounts because you're running some properties on the side. I think it turns into are you managing those properties during the week, possibly? Because I mean, it's not hermetically sealed. You're not just dealing with stuff on the weekend and then other stuff during the week. You can't close off one life. And I think that's maybe VLOK that Jeanette spoke about, is you're sitting there and you're thinking, and this is generally what happens, is you're thinking, if I really do well on this renting out business, I may buy another house and another house, and it may actually take over my job. So, I mean, that's something to consider. I don't think necessarily just per se that you have houses that you rent out and you generally do the admin on the weekend, that it is a conflict of interest. But ultimately, like Neil says with his scenario on the soccer coach, if it starts impinging on your work, then yes, it may be something to look at.
All right, guys. Yeah.
I think an important point is we need to look at what we're actually dealing with. So is there a conflict of interest? Is there interest that the employer has that is different to the interest that the employee has? So that ties up with what Courtney is saying. If there's a time interest, in other words, it's taking away from what you need to be able to do for your employer, or if there's a financial interest that should be coming to your employer that shouldn't necessarily be going to you. And if anyone has an interest that they're not sure about whether or not it is a conflict, it needs to be disclosed. Rather be sure. And that's also why it needs to be properly managed, so that employers are able to take those decisions for themselves. And it's not left up to employees to sort of live in the grey and wonder and take the silent route because they don't really want the passive income to be taken away.
Yeah, I think that's absolutely right. If there is doubt, disclose. I think that's probably the safest approach. But again, it boils down to the policy that an employer has crafted and what your obligations are as an employee. On this rental issue, if you're leasing a property to your employer, that may constitute a conflict of interest because you have a profit motive, as we saw with the other matter. But yeah, I think that's it for this webinar, guys. I think it's been a great one. Can I just thank all the panelists, GAEL, Courtney and Jeanette. I think you guys gave us quite a bit of insight into the whole matter. This webinar has been recorded, so it'll be on our YouTube channel as well. And just keep a lookout for our next webinar. Thanks a lot and see you soon.